Hello, and thank you for tuning in to the Los Angeles Housing Department presentation on the no-fault eviction process. The information you're going to hear today is in effect as of August 2025 and is subject to change as new laws take effect and other changes happen. Be aware that relocation assistance fees go up on July 1st of every calendar year. The information is only intended for City of Los Angeles residential units. This information is not for commercial units. This information is not for properties that are located outside of the City of Los Angeles. This information is provided for general informational purposes only, and it is not intended to constitute legal advice. If you require legal advice, please consult with an attorney. Today we're going to cover these 6 topics. Number 1, location inside the city of LA or outside the city, such as another city or an unincorporated area of Los Angeles County. Number 2, 2 different laws, the Rent Stabilization Ordinance and the Just Cause for Eviction Ordinance. Number 3, legal reasons for eviction, at-fault reasons or no-fault reasons. Number 4, relocation assistance fees, regular or resident protection ordinance, RPO. Number 5, landlord forms to file for no-fault evictions by mail or in person. And lastly, number 6, how to contact the department by phone or by email. How to know if a property is located in the city of Los Angeles. On the image you can see here, the area shaded in red is located in the city limits. The area that is not shaded in red is located in the unincorporated Los Angeles County or in other cities, such as Glendale, Burbank, San Fernando, etc. If you live in the city of Los Angeles, if the property is located in the city of Los Angeles, it should be serviced by the Los Angeles Department of Water and Power. And also, if you were to dial 911, you should receive a response from LAPD. If instead you get a response from the sheriff, then you are most likely located in an unincorporated area. You can look up the property's location using the link at the bottom, www.zemus.lacity.org. And if it shows up in a colored area of that map, you are located in the city of Los Angeles. If it shows up in a white background or does not show up at all, then it is not located in the city of Los Angeles. You can also go to this link, neighborhoodinfo.lacity.org/$, enter your address. If you get a message, nothing found, then you are not located in the city of Los Angeles. If you are not located in the city of Los Angeles, for information about relevant laws, you may contact the LA County by telephone at 833-223-7368 or at this email address or this website. The 2 laws. The Rent Stabilization Ordinance, often called RSO or RSO, also sometimes known as rent control, versus the Just Cause for Eviction Ordinance, known as JCO. The RSO applies to properties that were built on or before October 1, 1978, and are located in the city of Los Angeles. It also applies to Ellis replacement units that were built after July 16, 2007. It applies at all times. It regulates annual rent increases, requires legal reason to evict, and requires a relocation assistance fee payment from the landlord to the tenant for no-fault evictions. The JCO also applies only within the city of Los Angeles and generally applies to the residential units that are not covered by the RSO. So these can be built after October 1, 1978. It could be single-family dwellings, etc. It applies after the expiration of the initial lease or after 6 months of continuous occupancy by the tenant, whichever comes first. It does not regulate annual rent increases, although rent increases may be regulated by other state laws. It does require a legal reason to evict, and it does require a relocation payment for no-fault evictions. If you go to zemus.lacity.org and you enter the address, you'll find an RSO field. If it says yes, this means the property is subject to the RSO. If it says no, then it is not subject to the RSO. Please be aware that Zemus, while usually accurate, is not 100% accurate and is not updated in the moment. So information available from the Los Angeles Housing Department will be more accurate than information you obtain from Zemus. You can contact the Housing Department by texting the letters RSO to 855-880-7368, enter the address, and you'll receive a reply indicating whether or not the property is subject to the RSO. If you have very specific questions about whether or not the property is subject to the RSO, you can contact the Housing Department and ask for our RSO determination unit. Legal reasons for eviction under the RSO and the JCO. Both allow evictions for at-fault reasons. This is where the tenant has done something wrong. For instance, non-payment of rent or a lease violation. For example, the tenant has violated a covenant of the rental agreement. Nuisance. If the tenant is committing or allowing a nuisance at the property, this is a legal reason for eviction. Also, illegal purpose. This can be things such as illegal drug or gang activity at the property, unauthorized use of the property, or other illegal purposes. Also, failure to renew a similar lease. This applies, for example, if a tenant has a one-year lease that requires renewal for another one-year period, and the tenant is trying to insist that they go month to month and refuses to sign a new one-year lease. That can be grounds for eviction. Denial of access into the unit. If the landlord has given proper written notice 24 hours in advance as required by state law, and the tenant is not allowing legal access, that can be grounds for eviction. Subtenant not approved. This means that after the tenancy has ended, there's no one residing at the property other than a subtenant who is not previously approved or authorized by the landlord. So basically, a tenant cannot just move out and install a stranger in the unit. Also, failure to comply with an approved tenant habitability plan. This only applies to RSO units. If a THP is required, you'll be informed of that by code enforcement. No-fault evictions are the reasons that require the owner to pay a relocation assistance fee to the tenant. These include, number one, occupancy by the property owner, a close family member, or a resident manager. There are several restrictions that apply here, so we recommend that you look to Los Angeles Municipal Code Section 151.30. Also, another good source of information is the LAHD website. There you can find a link to the Los Angeles Municipal Code as well as a summary of these restrictions. Examples of these restrictions, for instance, are that the landlord must first apply for the most recent tenant in a comparable unit and is not able to evict a tenant who is protected because they've been there for at least 10 years and are over 62 years of age or disabled. Number two, withdrawal from rental use. So if you have an RSO property, you can withdraw the entire property, that is all the units on the parcel, from rental housing use by using the Ellis Act. The forms for all these types of evictions are also available on the LHD website. If you go to the forms page and then under the rent tab, you can find the Ellis Act eviction packet as well as the declaration forms for all of these other reasons. Number three is withdrawal or demolition of a non-RSO unit. So if your property is subject to the JCO, you can also evict a tenant in order to permanently withdraw the property from rental housing use or in order to demolish the property. Number four, to comply with a government agency order. For example, if the housing department or building and safety or another government agency has ordered that the unit be vacated, that is a reason for a no-fault eviction. Number five, converting to affordable housing. Number six, converting to residential hotel. Number seven, if the property is owned by HUD and it's going to be sold. No-fault evictions must have a legal reason to evict the tenant. The landlord must file a declaration of intent to evict with LHD prior to serving the eviction notice, also known as the notice of termination of tenancy. This notice generally will be of 30 days, 60 days for most tenants, 90 days for Section 8 tenants, 120 days minimum for Ellis Act tenants, etc. This must be done in compliance with state laws, including the Civil Code and the Code of Civil Procedure. Number three, the eviction notice must state the reason for the eviction. Number four, the eviction notice may be served any time after the declaration is filed, except in cases of RSO Ellis Act evictions, where the termination notice must be served on the file date, which is the same day that the forms are mailed to the LA Housing Department by first-class mail, and we will be basing that on the postmark date. Number five, eviction notices must be filed with LHD within 3 business days after service on a tenant. This is known as our electronic filing system. All eviction notices, whether for at-fault or no-fault evictions, must be submitted to the Housing Department within 3 business days. And number six, the landlord must pay relocation assistance to the tenant for no-fault evictions within 15 days after service of the eviction notice. The relocation assistance fee may be paid either directly to the tenant, such as a money order, or may be paid into an escrow account, and within 15 days, the tenant will be provided with escrow instructions informing them how they can withdraw the money as needed for legitimate moving expenses, and ultimately the tenant will receive whatever remaining balance within 3 days after they permanently vacate. This is a chart showing the current relocation assistance fee amounts. These are the amounts that took effect July 1, 2025 and will remain in effect through June 30, 2026. As you can see, an eligible household of less than 3 years would receive $10,650. These amounts are per tenancy and not per tenant. So everyone in the unit shares the amount in a pro rata basis, equal amounts to each person. An eligible tenant who's been there for 3 or more years or is low income would receive $13,950. Tenants renting in a mom and pop property would receive $10,200. This is only available for owner or family occupancy evictions. So mom and pop only applies to one type of eviction. And finally, single family dwellings owned by a natural person under the JCO, the relocation fee amount will be 1 month's rent. This is where the property contains no more than one single family dwelling on the lot, and it's owned by a natural person. Qualified household is one where there is a minor dependent child, a person that is 62 years of age or older, or a person that is disabled or handicapped. For those households, a tenancy of less than 3 years would receive $22,450, 3 years or more, or low income, $26,550, mom and pop, $20,600. And for single family dwellings under the JCO, still 1 month's rent. Those mom and pop rates are only for owner or family occupancy evictions of units that are owned by natural persons who own no more than 4 dwelling units, plus a single family dwelling on a separate lot in the city of LA. And the landlord cannot have used this fee in the last 3 years, and the family member who is going to take occupancy cannot own their own residential property in the city of Los Angeles. If you meet all these requirements, you get a slightly lower relocation assistance fee amount. The single family dwelling under the JCO fees apply if the property is owned by a natural person who owns no more than 4 dwelling units and 1 single family dwelling on a separate lot in the city of Los Angeles. And condos are not considered a single family dwelling. A single family dwelling is basically a house alone on the lot. Here is a chart of relocation assistance fees under the Resident Protections Ordinance. These also are effective July 1, 2025 through June 30, 2026. The Resident Protections Ordinance, or the RPO, took effect February 11, 2025, and there is a 1-for-1 replacement requirement for new construction projects that result in the demolition of RSO units. So these relocation assistance fee amounts apply for Ellis Act evictions, where the intended future use is to demolish and build something new. In those cases, a low-income tenant would be entitled to $84,750. A very low-income tenant would be entitled to $93,750, and an extremely low tenant to $111,900,000. There is a HUD chart that is linked to this chart here. It's highlighted in blue. It is called Relocation Assistance Bulletin B. By using that link, you can see the HUD chart that is used to identify the income levels. Occupants who are being evicted under the RPO must be allowed to occupy their units until 6 months before the start of new construction activities. Lower income households must receive a relocation payment from Chart B, or an approved comparable replacement unit, or an approved individualized relocation assistance plan in compliance with state law. So these are 3 options, A, B, and C. When the housing department receives the Ellis Act packet, the landlord must identify which of those options they intend to use. Whenever the housing department receives a declaration for a no-fault eviction, we are going to refer that case to the city's relocation consultant. Currently, that is a company called Interwest. They're going to do 4 things. Number 1, they're going to determine which relocation fee amount applies. Other than the special 1 month's rent, which is for JCO houses, the JCO and RSO relocation assistance fee amounts are the same. So Interwest will interview the tenant and select the appropriate relocation amount from Chart A. Both the landlord and the tenant have 15 days after the Interwest determination in order to appeal if you believe that the Interwest determination was incorrect. Interwest will also provide rental listings to the tenant, free transportation so the tenant can view a prospective new unit, and answer questions about relocation payments and escrow accounts. The Interwest services are funded by the filing fees that the landlord pays when filing the forms with the housing department. As I mentioned earlier, relocation fees can be paid by direct payment or into an escrow account with the fees deposited within 15 days and escrow instructions provided to the tenant. If the landlord is not clear whether the tenant will be eligible or qualified, the landlord can deposit into escrow the eligible relocation fee amount. And then if Interwest determines that the tenant is actually qualified for the higher amount, the landlord has a reasonable amount of time, which is an additional 15 days, to go back and bolster the escrow account to the higher relocation fee amount. Also, owners may deduct rental debt from the relocation amount. This is accumulated back rent that can be taken out of the relocation fee with the remainder still going to the tenant. It is suggested that landlords provide tenants an accounting of rental debt. Deductions are not allowed for government order evictions, and this is because generally the collection of rent is not legal for an unapproved unit at all. As mentioned earlier, you can find these forms by going to the housing department website, and here you see a link. If you use this link, you'll then be asked to click on RSO versus JCO in order to direct you to the correct forms. If you're filing an Ellis Act declaration, it's necessary to schedule an appointment with an LHD analyst. This is a telephonic appointment, and you'll create an Angelino account, select the date and time of the appointment, download the Ellis packet and complete the forms, review all the instructions, upload the completed forms, and then meet with the analyst for final instructions. This is not the filing of your application. This is a preliminary appointment designed to make sure that all of your forms are ready to be filed. You will then receive an email with directions on how to properly mail in your Ellis Act application. As mentioned earlier, the first class mail postmark will be the file date. Here's a list of the current filing fees, which took effect July 1, 2025 and remain in effect through June 30 of 2026. So for instance, if you're evicting 2 units and one is an eligible tenant, the other is a qualified tenant, you'll pay $604 for the eligible tenant, $971 for the qualified tenant. Relocation service administrative fee for both, The demolition monitoring fee is due in order to obtain housing department clearance on a demolition permit if you need that. The relocation assistance dispute fee is only due if you're filing an appeal. And lastly, if this is an owner occupancy declaration, there's a $75 fee per unit for that. Non-Ellis Act declarations can be filed by delivery in person to a housing department public counter. We request that you please make an appointment to schedule a time and date when you will go to the counter to submit the forms. You can also submit by mail to this listed address, LAHD, Landlord Declarations, P.O. Box 17100, Los Angeles, California, 90017. Please remember, if you mail, you have to include your filing fees. These can be paid by cash, credit card, or check. Obviously, you're not going to mail cash or credit card, so if you're mailing a check, please make it payable to City of Los Angeles -LAHD. Please submit a copy of your grant deed. If the property is owned by a trust, please submit a copy of the trust instrument, which identifies the trustee, the trustor, and the beneficiary. If the applicant is a business entity, please submit business documents necessary to identify the manager or the person authorized by that company in order to file these forms. So for instance, for an LLC, we're going to ask to see the operating agreement. A reminder here in red, Ellis Act forms can only be filed after having an appointment with an analyst. Do not mail Ellis Act forms unless you've been instructed by the analyst to do so. Here's how to file a copy of the notice to terminate tenancy. As mentioned earlier, this has to be done within 3 business days of service onto the tenant, according to Municipal Code Section 151.09C9 and 165.05B5. These eviction notices can be filed in 2 ways. Online is the best method, and you see a link there through your Angelino account to upload. The other method is by U.S. mail with a cover sheet to the listed P.O. Box 17850, Los Angeles, California, 90017. Here's a summary of the process that we have covered today in this presentation. I see a couple people have raised their hands. Please, once the presentation has ended, I encourage you to enter your questions in the chat. Number 1, RSO and JCO require filing of a declaration of intent to evict and payment of a relocation fee. Number 2, landlord will be notified by LHD that their declaration forms were received by LHD, and we're going to assign a case number and we're going to assign an analyst. Number 3, tenants will be contacted by the city's relocation consultant, Interwest, to provide relocation services. Number 4, landlord and tenant will be notified of the relocation amount determination that has been made by Interwest. Number 5, the landlord notifies the tenant of the requirement to move out via a written eviction notice, and the landlord files a copy of that notice with LHD within 3 business days. And number 6, the landlord pays the relocation assistance fees within 15 days of that eviction notice. It's a pretty basic process, but it is very technical. If it's possible to be represented by an attorney, it's advisable to do that. If you have questions for the housing department, you can reach our general hotline by calling 866-557-7368. You can also use that same number to RSVP for upcoming webinars. You can email your questions to Ask Housing using this link. We also encourage you to sign up for our electronic newsletter. And finally, you can watch YouTube videos, including today's webinar, by going to the LHD YouTube channel at LHD_housing/videos. I want to thank you all for attending today's presentation.